Good evening and welcome to this November 22nd, 2021 meeting of the Village of Lake Bluff Board of Trustees. Clerk, please call the roll.
Trustee Inkeman.
Here.
Trustee Brienne.
Here.
Trustee Fisher.
Here.
Trustee Markey.
Here.
Trustee Rabin.
Here.
Trustee Ryder.
Here.
Thank you. Please stand and join me in reciting the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Next is the consideration of the minutes of the November 8th, 2021 Village Board regular meeting. Is there a motion to approve the minutes?
So moved.
Thank you. A second?
Second.
Do we have changes?
There were changes. I circulated this one little section, redlining comments from Trustee Ryder. Just want to make sure everybody saw that.
Anything else? Thank you. Clerk, please call the roll.
Trustee Brienne.
Aye.
Trustee Fisher.
Aye.
Trustee Markey.
Aye.
Trustee Rabin.
Aye.
Trustee Ryder.
Aye.
Trustee Inkeman.
Aye.
Thank you. Next is our non-agenda items and visitors. The Village President and Board of Trustees allocate 15 minutes during this item for those individuals who would like the opportunity to address the Village Board of Trustees on any matter not listed on the agenda. Each person addressing the Village Board of Trustees is asked to limit their comments to a maximum of 5 minutes. Is there anybody online who?
No one is currently raising their hand.
Thank you. Next is item number 5. The Village Board sets the order of a meeting. The Village President and Board of Trustees will entertain requests from anyone present on the order of business to be conducted during the Village Board meeting. Any requests?
Not at all.
You can probably take item 11 out of order if you'd like.
Sure, we could go with item number 11 next.
If there's no objection.
Is there any objection?
Drew, do we have anybody queued up, just in case people are running behind? I'm assuming there might be some people who want to speak to
There
the Stonebridge issue.
are 3 on the call that have been on for several minutes. There was a 4th earlier, but person seemed to check out.
Let's proceed with item 11. Next is item 11, a resolution approving a settlement agreement with SB 2011 Stonebridge Development located at 136 Green Bay Road. Is there a motion to approve a resolution?
So moved.
Thank you.
Second.
Second, thank you. In April 2011, the Roanoke Group, through its legal entity SB 2011 LLC, purchased the Stonebridge property and became the successor developer under the development agreement and the PRD ordinance that were originally granted to the previous owner and developer in 2006. In conjunction with a transfer of a property to SB 2011 on April 25, 2011, the village adopted Ordinance 2011-07, which amended the PRD ordinance. In 2020, various disputes arose between the developer and the village, resulting in 2 lawsuits being filed. On March 3rd, number 1, on March 3rd, 2020, SB 2011 filed a lawsuit in the Circuit Court of Lake County that seeks to terminate the development agreement and PRD ordinance, release the existing letter of credit posted to the village, and require certain demolition permits to be issued. Number 2, on March 11, 2020, the village filed a complaint in the Circuit Court of Lake County seeking injunctive relief and fines related to SB 2011's maintenance, removal, and replacement of certain fences on the property. Both cases were consolidated before Judge Hoffman in Lake County Circuit Court. Both complaints survived motions to dismiss, and extensive written and oral discovery was proceeding. Following settlement conferences with Judge Hoffman, both the village and SB 2011 undertook extensive settlement discussions that have resulted in a proposed settlement agreement. The settlement agreement would, among other things, number one, avoid further costs, delay and uncertainty with regards to the property caused by the lawsuits. Number two, settle and compromise the claims set forth in the lawsuit. Number three, waive similar, related, or additional claims and defenses. And number four, provide for clarity with the property. The terms of a settlement agreement and related issues are described in detail in the attached agreement, Q&A documents, and the November 9, 2021 public memorandum from village attorney Peter Friedman. Procedurally, the settlement agreement is subject to the approval of a village board by resolution duly accepted. For information, we have 4 documents in the agenda: the resolution authorizing approval of a settlement agreement, the memorandum from village attorney Peter Friedman regarding the settlement agreement, and number 4, the settlement agreement summary and questions and answer regarding settlement agreement terms. Peter?
Are we going to go through the PowerPoint? Okay. So we have a PowerPoint to go through the fundamentals of the settlement agreement. As the village president said, the settlement agreement, which is one document, requires one resolution to approve by the village board, will result in the village dismissing its complaint against SB 2011 and SB 2011 dismissing its complaint against the village, both with prejudice, both with parties to bear their own costs, and with mutual releases, so that those claims and related claims identified in those cases will be dismissed with prejudice forever. As you know, the current property is governed by the existing PUD, which was amended in 2011. The settlement agreement will allow for the PRD to be revoked after the required procedure, and so the property will revert to its underlying E1 zoning district. The settlement agreement contains no other substantive commitments or agreements between the parties as to what will be approved if there's another development approval sought from the village. So it's E1, and a future developer will start from square one with regard to a new proposal. The settlement agreement requires that the existing plat of subdivision, which, as you know, and as you can see from this overlay plat, has numerous individual lots for the previously approved 85 units. Those will be wiped out, and there'll be a 5-lot subdivision. The parties had intended this to be a 1-lot subdivision, but the Plat Act does not allow you to create lots on all sides or both sides of a dedicated right-of-way. So we divided the property by its minimum number of lots, which is 5. The 2 historic structures on the property are the manor house and the gatehouse. The SB 2011 has already gone through the advisory review process, has filed a complete application for the demolition of both of these structures. The only thing that was preventing that was the litigation and the village's position under its development agreement. Legally, those properties, those buildings will be allowed to be demolished. However, the settlement agreement provides for the manor house that there's a 90-day period before which the manor house cannot be demolished. That period will allow the village to identify and have removed certain architectural artifacts that are worth saving and preserving. And then over the, and then also the owner is required to notify the village if it receives any proposals for the property that would maintain the manor house. owner is not required to accept those proposals, but but they do have to identify notify the village that if one is received. Gatehouse has a longer period. Gatehouse has a 5-month period for marketing. It will be marketed by a national real estate group that the village will have a role in selecting, and the village there will also be entitled to information about the marketing materials, any offers received, etc. Again, though, the ultimate decision about whether to accept any offers is with the property owner. Drew, you want to?
Yeah, so I wanted to let the board know that we've already started going through the property, and outside and interior. We picked the worst day last week, both raining and cold, and so we went through the home and started cataloging. And we walked through with the contractor. Ultimately, we expect to get a list of items. We've all agreed upon the items, and the contractor will give us a price for that, and we can report that back to the board. You can have choice in terms of what because there's going to be some price breaks, and some things will become probably prohibitive to try to remove. But a lot of the items there, good news, the stained glass windows are all in great shape. Interesting little small aside, some of that, the actual paneled walls, some of them look like they are burled walnut, and the carpenter who was with us was actively drooling. And but some of those things aren't expressly itemized in the agreement that the village can actually capture through this, but they have the developer owner, if we can reach terms to that they may allow us to get some of these things. But fireplaces are on the list, the stained glass windows, the doors. Interestingly, again, the hardware on the doors is extremely valuable, according to the firm we're working with. And the doors, not so much, but the hardware most certainly is. But plenty of artifacts in there, and the village will have to choose what it wants to do. Obviously, I think economics will play a role in that.
So the protection of the front 10 acres. Under our PRD and the development agreement, the property owner back in 2006 was required and did record a conservation easement against the property, against the front 10 acres. As part of the settlement agreement, the village agreed not to object if and when the property owner decides to seek to extinguish that conservation easement. However, there is a requirement that a restrictive covenant be recorded against the property soon after we execute the settlement agreement, and that restrictive covenant restricts any development or buildings on the front 10 acres, and that restrictive covenant kicks in simultaneously with the extinguishment of the conservation easement. So for the village's purposes and the front 10 acres, there should be no real difference at all between the maintenance of the front 10 acres between the time it's been under the conservation easement and the time it will be under the restrictive covenant. For future development of the property, the settlement agreement lays this out, that it'll either be a straight E1 development with no variation, so E1 as of right, or it'll be under a planned residential development under any zoning district. But it must, if it's not E1 as of right, it has to be a PRD. And with regard to the restrictive covenant, what that means is so long as it is in E1, the restrictive covenant will remain on the property. If it is developed as a PRD, at the time that the village approves the ordinance approving that PRD, the restrictive covenant that is in the settlement agreement will go away. However, the village will have the right to seek the same or similar protection as a condition to any approval of a future PRD. Additional provisions there's a replacement letter of credit. The old letter of credit is not necessary because it was securing things that are not relevant anymore because the development failed. But there'll be a replacement letter of credit of $135,000 specifically to protect the maintenance of the front 10 acres, among other things. The manor house demolition will incur a standard demolition fee. The fence along the West Witchwood property line will be replaced, similar to the fence that was there before, subject to the village's approval, the village administrator's approval. Any construction fencing will be around the perimeter of the actual construction, not around the entire property. And the owner has indicated a desire, and the village has agreed, to allow the entry bridge to be completed, subject to the village's review and approval. And I think that summarizes the agreement. I do want to just thank the board and Susan and Kate for all of their efforts, and Drew and staff's efforts. This was a long process, 3 or 4 months. It was the development agreement and the PRD, as the village desired, put significant restrictions on the development of the property. So to unwind all that and to allow an opportunity for the property to be developed was a complicated matter, and I just wanted to applaud you all for your guidance and dedication on that.
Thank you very much. Next, the board will entertain a member of the public questions. Do we have comments from the public? Please state your name and your address. Thank you.
My name is Stephanie Bjork. My husband and I own a house at 1216 North Sheridan Road in Lake Forest and 414 East Prospect in Lake Bluff.
Thank you.
I provided this morning to Drew, and I have provided in the past to the various boards and have spoken before you before. My husband and I are the only, to date, I believe, third-party enforcer of a conservation easement in the United States. The case is Bjork v. Draper, and we prevailed to the Illinois Supreme Court in an 11-year lawsuit to enforce a federal conservation easement. So this situation is very similar to the case before you tonight. What I don't see provided to all of you, which is critical, is the federal conservation easement document that the village was a party of, that sets out very specifically what the terms and conditions are that was agreed to and what the benefits on behalf of the taxpayer. There's a public interest in this property. And very respectfully to Mr. Friedman, Mr. O'Donnell, who is the attorney representing the developer, was the attorney representing the party against us in this case for 11 years. So we prevailed on the fact that all of the amendments that had been agreed to between the grantor and the grantee were invalidated by the courts. And the reason they were invalidated is that they violated the conservation easement document. And you can see what I gave you this morning was a very researched and very extensive document to the point of the perpetuity standards put in place by the federal government and the Internal Revenue Service for the purpose of protecting the public interest. Because the public pays for these in multiple ways over time, and it's for a public benefit. And I have to say, I was disturbed to see in your agreement the essential gutting of the potential third-party enforcer provision, which is very clear in Illinois law that there is a provision for those within 500 feet to enforce this easement. And that the reason for that is the IRS makes very clear, and you can see in this document in certain cases on audit, if there's an agreement between a grantor and a grantee, which was the case in our case, the same argument was made in our case that the two parties had agreed to these changes, and therefore they were good. And the court invalidated those because they violated the conservation easement and the document. So I really want to be respectful to Mr. Friedman. My husband and I walked this for a lot of years. and in a way are back at it again. This is a substantial tax benefit to the people involved, and it's paid for by the taxpayer. And if there isn't any interest by the grantor and the grantee to enforce these things, absent a responsible third party, they don't get enforced. So there are multiple incidents to counter something that Drew said of no listed properties in the village at the last meeting I was at. There are multiple federal easements in this village. There are many in Lake Forest. Open lands on the stand, in our case, admitted to, I can't remember whether the number was 20 or 40, but they had amended the documents and essentially had assumed that they could do that. And I think our case is cited by the Internal Revenue Service in their cases for conservation easement enforcement. The provisions for the enforcing party, in our case, as the third party, we had to pay our legal fees because the documents are written such that the easement holder, the 501c3 or the municipality or the not-for-profit, if they enforce the document that they have, their legal fees are reimbursed. And in the state of Illinois, actually goes so far as to grant the value of the easement to the enforcer. So they're really, from my experience and from my perspective, the village can enforce this easement and get the property back and isn't out legal fees. So I don't understand the essential need. It doesn't serve the public that anything other than enforcing the original easement is done. And I understand that these go before the court, as ours did. I would hope that Lake County would remember our case as a very important case, and would invalidate whatever agreement the trustees agree to tonight, because my understanding from our case is that what you're agreeing to is not law, current law. And the Nancy McLaughlin, for point of reference in the article that I've given you, Nancy McLaughlin is the current IRS drafter of conservation enforcement law, and she is also the liaison with Chuck Grassley's office for conservation easement enforcement and regulation. So I chose that article because this really is a perpetuity discussion. And my concern about not adhering to what was a very principled and hard fought, obviously never intended case for us. We had been instructed by our attorney that if we sent a letter telling them you just can't do this, they wouldn't. And we ended up 11 years later in front of the Illinois Supreme Court, which would not hear the appeal from the other party. So to change any of the invalidated amendments. So all of the amendments were invalidated, and my hope tonight is that the trustees will understand this is not just about this one property. You have Crabtree potentially involved, you have Shore Acres potentially involved, you have many properties, including the historic part of town, the train station, the original camp meeting area. You have many federal documents that have been filed with restrictions on these properties. Our home at 414 East Prospect, which is one of the last remaining, if not the last remaining camp meeting house on the original plat, still carries on our title the original restrictions that are on that original 1860s school, church, grant, not-for-profit. So it's still in force, it's still in play, and And I understand the issues. I understand the pressures from the developers. I understand because I've lived it. The subsequent owners in this day and age, and maybe always, feel they have a right to do what they want with their properties. We took tremendous pains to make sure that the new purchaser of the house that we had been in litigation with was well aware of what the document were and the fact that we were still there, and we didn't ever want to go through this again. And I think it's important that the subrogation through any financing, which has to be by law to be enforced and effective, those financial documents have to be subrogated and signed off on. The taxing body has to subrogate and has to sign off on this to get the benefit. All the parties involved have to agree that they're going to adhere to this document. So it's a serious commitment, because what happens is the taxpayer loses every bit of the benefit and the protection that they were given by right if these things aren't enforced. So I really appreciate everyone's time. I've spoken on this through the years. I understand the situation and the pressure, but it's a very principled, simple law. This is a public interest. And particularly, I think, removing the public from the benefit that they were given. I think there's other avenues that can be done, and I would hope, if the village continues this position, I would hope that the courts realize that it would be in direct opposition to our case and the current law that's on the books. So I appreciate your time. Thank you so much.
Thank you, Mrs. Bjorn. Any more comments from this room? Thank you. Do we have comments online?
Is there anyone who is participating virtually that has a comment to make? If so, please raise your hand and you can be recognized.
Meanwhile,
No one's raising their hand.
thank you. Any comments from our board?
Peter, can you address Mrs. Bjork's comments? Because I do think that, I read actually through the opinion from the Illinois Appellate Court, and I did a little bit of research on what she's talking about. Then you and I have spoken, and I wanted to know what your thoughts are on this.
So, and I read it too, and I appreciate all the comments. I didn't take anything disrespectful at all. The conservation easements that's recorded against the property right now, the village is not the grantor or the grantee under that document. The village only becomes the grantor after the development is developed and the property is transferred to the village, which never happened. All that the village has done in the agreement is say that it will not object. There's nothing in the agreement to the extinguishment. That does not excuse the grantor and or the grantee from full compliance with the law, and particularly with regard to the extinguishment of the conservation easement. Under the document itself, it can't be extinguished except in pursuant to judicial proceeding, and there are other property owners within 500 feet of the property. So the village, in all of the negotiations with regard to the settlement agreement, made no statements or certainly no promises or agreements or anything to excuse the grantor or grantee from whatever is required to comply with the conservation easement so long as it continues to exist, and with regard to whatever is required if they desire to extinguish it. All that all that the village agrees to under the settlement agreement is that it will not object. But the perpetuity standards continue to be the law. And so the grantor and the grantee are going to have to deal with that in court. So I think that those are my comments on that.
So Peter, just to clarify, a positive vote tonight to accept what's in front of us would not take away any of the rights of the residents of Lake Bluff to protect those 10 acres.
Correct, to the extent that they have rights under the statute and the conservation easement, all that we are agreeing is that the village as an entity will not object to the extinguishment.
So I've heard it referenced elsewhere that we had agreed or were agreeing to exchange a conservation easement for a restrictive covenant. And my understanding is that we, as you said, have simply said that we will not oppose actively as a village the conservation easement being extinguished if it can properly be extinguished pursuant to the terms of the document itself and judicial law, and it sounds like the Borks know quite a bit about that. However, what we did do was say, if and when they get that extinguished, a restrictive covenant will take its place, right, upon the extinguishment of the conservation easement. Understanding very well the conservation easement properly drafted and properly deeded to us, which hadn't happened yet, would have been a much stronger protection. We fully understand that. We weren't, perhaps it was impossible to even get it developed with that conservation easement intact, but we certainly were years and years and years away from that happening. And so it's not an exchange of a conservation easement, a very strong conservation easement in exchange for a weak or restrictive covenant, so much as a backstop. Should they succeed in getting the conservation easement removed, which is up to them, we will have the backstop of the restrictive covenant to come in behind it and at least protect those 10 acres. That's, Kate, that's a simplified way of talking about it, but that was I think, where we were getting at.
I agree with that characterization.
I think it's also worth pointing out that there is the likelihood, having looked at the Bjork's case, if that the property owner may be unsuccessful, and that my understanding is that has no impact on the rest of the settlement agreement. So they're really bifurcated issues. But I do want to point out that I do appreciate the, what Mrs. Bjork's point is about the consequences, and I do think we need to be mindful of that as a municipality, because that's a really cogent point. And I don't want there to be the impression, and I think that Trustee Ryder's right to mention it, that this was something that we gave away without serious contemplation. It was, I'll speak for myself personally, since I was involved in these negotiations, this was an incredibly difficult thing for me to do on this specific point for myriad reasons. I understand the tax benefit and the cost to the taxpayer over the years as a result of this easement, and I don't take that lightly at all. And none of us should. Anytime, you all have heard me talk about this before, anytime we're talking about tax dollars. This was a really, really difficult thing. It was a Hobson's choice, in essence. We were in a really bad situation. So I want to reiterate what Trustee Ryder just said. We were in a position where this would had to do, or we weren't going to get to where we are today. And then we would just be in continuous litigation. I'm not sure that ameliorates much, but it is the truth about how we got to where we are. But I don't want to underestimate the seriousness of what this means, because there could be unforeseen consequences. So, but I do think it's important to know that whatever happens in court with Mr. Kite and his efforts to extinguish this have no bearing on the rest of this, and I think that's important. Because we don't know what the outcome of that's gonna be or how long it would take, right?
Correct.
And what rather than have nothing at the, should he be successful, we will at least have the restrictive covenant as long as it remains in E1. Should he be successful in the conservation easement extinguishment, which is, I think, what was key to us. Excuse me.
Bless you.
Bless you.
Right, from a pure preservation standpoint, in terms of preserving the 10 acres, I think that's a separate issue. From an environmental standpoint, we were able to get that carve out, which was really important to all of us, and I think to the community. But again, I do understand the point, and I take it really seriously. I just think we were in a corner. And if we didn't do this, this was going to persist. So this is just I don't know how to characterize this any other way. And we just did the best that we could under the very, very difficult circumstances.
Correct. Thank you very much, Trustee Ryder, Trustee O'Brien. Do we have more public comment, Mrs. Bjorn?
Because the issue was just raised about extinguishment, it's important for the board to understand that it isn't
please-
just extinguishment.
Mrs. Bjorn, can you please put the microphone closer to your mouth?
This isn't just extinguishment. The consequences of that is that money gets paid back to somebody. So since that issue was raised, who is the holder of the easement? Where is the original document? Who are the parties involved? How much money was granted? Who has right to enforce? Have the property owners within 500 feet been notified? Is the court aware of our case, Mr. Friedman? Has that point been made? We fought very long and hard on the benefit of the public at great personal expense. Not only in dollars for legal fees, but in the consequences of the realization, which was very sad for us, that these really were not being enforced. When we filed suit, we assumed someone would ride in on the white horse and do what we thought they were going to do. We never expected that it would be us. And I think you're putting an understanding that you're putting a job that you could do onto the public to have to step into our shoes. They have no ability to recover their legal fees. You have ability to recover your legal fees. We do not. The provisions to return legal fees based on enforcement go to the holder of the easement.
We don't
So-
hold the easement.
So my questions, who holds the easement?
They're right
Who
there
has
in the
right to
document. I'm happy to
enforce?
provide you the document. We have the document. It's been recorded against the property.
Okay, who is the current holder of the easement?
The grantor is Stonebridge Lake Bluff LLC, and the grantee is Stonebridge Conservation NFP and Illinois Not-for-Profit Corporation.
So you're telling me that they are acting in their own interest on both sides of essentially the deal. So what I can tell you is if you read through very carefully the IRS guidelines that exist currently right now online, that is a particularly egregious violation, and the IRS should step in and audit. And so I made the point to Ms. Briand and to Drew in the past, and I think Mr. Friedman at some point, that my hope is that everybody would do their job properly, and this would not become a public spectacle or something that received negative publicity on any party, or put anyone in the position that they had to take the position that we took. And honestly, you've got a lot more of this coming down the road. And I understand the temptation to split the baby on this one, but I'm sorry, there's too much more at risk, including the metro station coming up. Lake Forest had a similar situation with their train station, and you can investigate how that went for them. So I appreciate it, but I think there's consequences here. I think the village has the potential to take more action in a positive way for the taxpayer than what's happening. And I also would take issue with the fact that what you're voting on tonight, that one-page document, that settlement agreement, makes specific reference to removing third parties as having any ability to impact this. And I have to tell you, that was a particular sore spot in our case. Illinois is a very unusual state in the fact that it gives the public within 500 feet standing to enforce. A lot of the states, we wouldn't have been able to take our case where we did, because we would have been denied standing. And your third party, removal of third party having right to enforce, I don't think you want to be on that side of that. If you look at state law, or Illinois state law on conservation easement right now, it's very specific that that's not allowed, that third parties have right to enforce. So I think at the very least, this should be something that that document should be rethought before it's submitted to the court, because I don't think it's accurate.
Thank you, Mrs. Bourne. Do we have more comments from the public in this room or online?
So, with all respect, I don't know the one-page document to which Ms. Bjork is referring. Peter, maybe you could help me? Because I'm reading the settlement agreement itself, and it merely states, the settlement agreement itself merely states that we are not going to be a party to, or oppose their effort to extinguish the conservation easement, and we've made no representations about, nor could we, I think, about anyone else's rights to object if they have such a right. Please disabuse me of that notion if I'm wrong, but I didn't understand us to be doing that.
That's correct. And remember, so I agree with everything you said. The only thing that's in here about a third-party beneficiary is that the parties, which is us and SB 2011, that's it, have said that no claim as a third-party beneficiary under this agreement by any person or entity will be made or be valid against the parties. We are not parties to the conservation easement, and I don't think anybody would interpret that as somehow allowing us, certainly not SB 2011, but also the village, from extinguishing whoever has rights to enforce the conservation easement. We don't have that authority in this document because those parties are not party to this agreement.
That was my understanding. And I'll read with interest the documents that we've been referred to. I'm afraid I have not yet read the case as Kate has, but nothing that I've read that we've talked about should give us any pause, I take it, that somehow the property owners within 500 feet, should they have rights today to enforce it, nothing we're doing, and by it I mean the conservation easement, nothing we're doing here is taking away anybody's rights under that conservation easement, other than we are saying we are not actively going into court to oppose their efforts to get it removed. They have to deal with IRS themselves. We're not party to that. nor are we party to the conservation easement for better or for worse.
Right. And there is no, the only court cases that are ongoing right now are, of course, the ones not
Where we're-
involving the conservation easement, but there's no court case right now involving the extinguishment of the conservation easement. There'll have to be one, but it hasn't been filed yet.
Thank you. Barbara?
Just based on what I heard from Mrs. Bjork, I have a couple of questions. I think there are 4 lawyers sitting up here, and I'm not one of them, so understand that this is from a layperson's perspective. There's lots of language that has very specific meaning that I don't fully know, but as a board member, I'm trying to just ask some questions. And it seemed to me like the 2 issues that I just wanted to know a little bit more about were, it seems like one of the points was that the grantor and the grantee of the conservation easement, of which we are not one of those, it seemed to be that there was an issue with these 2 parties being related and not valid and, you know, et cetera, et cetera, et cetera. But that's not something that we didn't draft it, we didn't create it, we're not either one of those parties. Whether that document should or should not have existed, I don't think we have any influence on. Am I reading that, right?
Well, I would just say this. I mean, the conservation easement was a required document attached to the development agreement that we required be recorded against the front 10 acres when the village granted the original PRD to protect the 10 acres.
So would we have then a duty to,
No, we have no, I mean, to the extent they have violated IRS regulations, to Susan's point, that's not, we're not the IRS.
Okay.
For our purposes, the front 10 acres have been preserved. And through a lot of work by the village administrator working with the developer to ensure that it's been preserved these 15 years.
okay, so then part 2 is the other part that I, as a layperson, a non-lawyer, think that I'm hearing is that the Bjorks at great personal expense have pursued this issue and have suffered for over a decade trying to see a positive resolution on their particular case, which they did eventually have that positive output. But her point seems to be that village, we should be doing something because we can be reimbursed should we prevail, as opposed to saying, we don't know that we should be doing anything, we shouldn't be doing anything. If somebody else wants to step in, have at it. But the point is that we have a different standing. And you know, that's new to me. I don't know if it's valid or not. But again, that's, to me, the point is that, yeah, somebody can step in, but who's got the chops, who's got the depth, who's got the knowledge, who's got the money? And I don't know how valid that is. So that's my lay interpretation.
Yeah, I'm not disputing at all that law, that if the village chose to enforce the conservation easement and was successful, there may very well be a right to reimbursement of legal fees. Not disputing that at all.
And so her question was, why don't we?
Well, that's, that's for you guys to answer, but I would say the one element that we haven't talked about yet is that at some point in this litigation or the next, the village was faced with the prospect of these documents going away without a settlement agreement, in which case there would have been no restrictive covenant coming after the conservation easement if it was extinguishable.
I understand that, and I
there-
think that point is well taken, and it's appreciated, but I'm just wondering about the other point, which was, so I don't understand what the implications of that would be, and so maybe that's not something to resolve today, but those were the two issues that I thought I just needed a little bit more clarification on.
I think the high level is that, you know, this was a negotiation. There were trade-offs, right? The village was trying to do what it could to secure a foothold in that front 10 acres. The developer made it clear that they didn't want to have a conservation easement moving forward and wanted to tear down historic structures. And all those trade-offs
Right.
developed around those two.
I'm not talking about that settlement at all. The thing I'm talking about is, should we step in, as in terms of if that original thing is enforceable, that original document with this grantor and that grantee of which we are not one.
Are you asking if we are able to step in as a third-party
Yes.
enforcer?
Yes.
Legally?
Yes.
Yes, but we've agreed in this settlement agreement not to do that.
In its place, we put a restrictive covenant, which
Got it.
gives us a protection.
This is all the connections just happening. Thank you.
And I think the comment is that, Mrs. Bjork is making, the point she's making is that by doing that, we have to be cognizant of what might occur in,
Yes,
as she noted,
yes,
Crabtree
yes.
and other properties.
But that doesn't mean.
It doesn't mean it
Okay.
will. What I'm saying is it's relevant to the degree that we have to be mindful
I see.
of that. We have always, because we were the party that insisted upon this.
Got it.
Even though we're not the grantee, which we could have been, if let's say somebody drafts a conservation easement, they can pick,
I see.
there are only 3 options under the statute in Illinois. And so it would be a municipality, not-for-profit that is conservation-minded, and then one other. And so that's the point, and I get it. I think it's a really, really serious point, and that's why I wanted to make sure that, that I say on the record that this was not dealt with in any flippant manner.
I see.
I'm not discounting anything, and I think we have to be just incredibly mindful. We do have, Crabtree is a good example, that's all in conservation easements.
Yes. Well, thank you. As a non-legal person, it's taking me hearing this 8,000 times before.
These are not easy. I don't
Yeah.
think this is easy. I mean, property law generally is just super complex, and so when you have, it seems odd, like why would a party that seems to not have an interest be able to enforce an interest
Yeah.
legally?
Yeah,
I
okay.
understand that.
And just maybe a history point too, and I wasn't here when this was adopted by the board, and Peter, maybe you can step in if I get this wrong, but the idea of how was this set up this way, or why was it set up this way,
Yeah.
right? That there would be a not-for-profit that's actually the developer at this point. Well, it was transitional. The idea was that over time, that when the development was approved, that the developer was responsible for improving and making the Jens Jensen historic 10 acres to where they should be. And over time, that it would take the development to fund those activities, and then they would turn over the keys to another grantee who could have been the village, could have been Lobola, but the idea, that's what was talked about then, it just never got there, right? Because
Yeah,
the development
yeah.
failed. So that was the transitionary nature of how that became
Got
the
it.
way it is, which I can imagine left people scratching their heads, like, well, that doesn't
I
make sense,
see.
right?
I see. Okay, well, it took 8,001, so thank you.
I just,
Thank-
I'm sorry. Go ahead.
Joy, please.
No, I just had a follow-up question to that. And again, I'm not a lawyer, so it slowly all comes together, like Barbara, for me. Just in response to what you were saying, Kate, about Crabtree Farms. So, and I guess this is also for you, Peter. If this is if we go ahead with this settlement, can it then be used in the future as kind of a
Precedent.
precedent? Thank you. Like if someone else wanted to do the same thing with the same kind of property?
I don't believe so. I assume, without prejudging any future decisions, that if any, that we do have, I believe, enforcement rights on the Crabtree conservation easements, and the village can exercise those if it chooses to. But just because we didn't, in this case, given all of these circumstances that don't exist in those other areas, I don't see, I'm always saying that there really isn't any precedent with regard to village legislative decisions. Each decision is separate. But particularly in this case, I do not think, it is, I don't think it's precedential against the village. Now, what I think the concern is that however the court decides this, if the court allows it to be extinguished, then perhaps that gives somebody else a better argument that they can extinguish their conservation easement. And, perhaps, I don't know what the court will do, I don't know what that decision will look like, but I think that's the concern, not that we're gonna be bound to not object again.
Okay, thanks.
I agree with that too, and I do think that the idea is that if a third party that has the enforcement capacity does not do so, regardless of the reason, that sets particular things in motion, domino theory. And I agree about Crabtree. So we were well aware of, and all of us, I think collectively are aware of this balancing test we all did. And I'm saying this because I think it's so important for everyone listening and watching to know this. We discussed all of this at length. And I want to say that this was just like I said, a Hobson's choice. There are risks involved, but there were also risks involved in not settling. And I don't love to bring everything down to dollars and cents, but this village has expended a phenomenal amount of money with this litigation. So I think what we tried to do was play out what would happen for sure with Peter's assistance in terms of legally, and what we thought was less likely. That's how we got here. I just think it's important for people to understand how we arrived at this, because this is probably the biggest thing that we, and Susan, I don't want to speak for you, but I think this is the biggest thing that we agreed to personally.
Thank you.
Yeah, it was important.
Thank you very much. So to this extent, I mean, to assure the public here present, it was great pain for us to come to these conclusions and to come to that decision and to come to that agreement. We have spent significant amount of time and money to come to this point. Are there any more comments?
I'm just going to say out loud the way that I'm kind of thinking about this conservation easement. I think we recognize that, and I think Mrs. Bjork's point about why leave the residents to handle this on their own ultimately, and I think the calculation we're making is that in order to have a deal with the developer, we needed to give up that right, but we put a restrictive covenant in its place. So and we're not party to the easement right now, so we have no right there. So to me, on the balance, we're protecting ourselves with the restrictive covenant, and I think the choice of not having a settlement to protect our right to be party to enforcing the easement later on, it just doesn't add up for me.
Thank you. Any last comment?
I just really quickly wanted to say, we have spent an enormous amount of time on this, hours and hours and hours, and I'm not speaking for Kate and Susan, who have spent even more, and Drew and Peter, so I'm just impressed that we're here, that we have a settlement. I know we had to give some things up in order to get where we are, but it was a compromise, and I'm hopeful that we can move forward, that property can be developed at some point, and that it can be just a gem in the city, in the village at some point.
Thank you. No more comments. So, any very, very last questions? Hearing none, I will call a vote on this motion. Clerk, could you please call the roll?
Do we need a motion? Do we have a motion?
We had a motion.
We did. Okay, apologies.
Go back.
No, we had a motion.
Yes, you did.
Okay.
You have a motion and a second. Yeah. It was.
Okay, so trustee Fisher,
Aye.
trustee Markey,
Aye.
trustee Rappin,
Aye.
trustee Ryder,
Aye.
trustee Inkman,
Aye.
trustee Brian.
Aye.
Thank you very much. And that closes the chapter on this item. Let's resume our agenda, and that would be item number 6, Village Finance Report. Item 6A, this is our warrant report for November 9 to 22nd, 2021. Is there a motion to approve this warrant?
So moved.
Second?
Second.
Thank you. Today, our summary of and background and reason for request is expenditures of village funds for payment of invoices in the amount of $268,211.85 for November 9 to November 22nd. I read the total expenditures of $268,211.85. Report and document attached, the warrant report for November 9 to November 22nd, 2021, again for $268,211.85. The invoice register report shows checks with a status of open or paid. All checks with a status of open are computer-generated checks for the board final approval. Checks with a status of paid are manual checks processed. Any question on this report?
I would just add, Trustee Inkerman had a question. Everybody knows she's chair of the Finance Committee. We were talking earlier today about, you're going to get a presentation and an update on the village's capital initiatives at the next board meeting. And one of the things she'd asked about was there were some expenditures related to the village's replacement of the water meters. And very close to the finish line there. I don't want to spoil it too much, but I think it'll be a good story to tell, and just want to do a little teaser. So, that's all I have.
Thank you. I'd love to hear about that. Any questions? It's a voice vote. All in favor?
Aye.
Any opposed? The motion carries.
It's a warrant. Should be roll call, yes?
It's a warrant. Okay, it's a roll call. Clerk, please call the roll.
Trustee Markey?
Aye.
Trustee Rappin?
Aye.
Trustee Ryder?
Aye.
Trustee Inkman?
Aye.
Trustee Brienne?
Aye.
Trustee Fisher?
Aye.
Thank you. Next is our October 2021 finance report. Is there a motion to approve the financial report?
Second.
Thank you. Attached for your consideration is, I should let Bettina do that. Sure. Finance Director O'Donnell, could you please, O'Connell, sorry. Could you please give us a summary of this report?
Sure. Monthly sales tax revenue on a cash basis for October fiscal year 22 is $336,012, which is $14,397 or 4.5% greater than fiscal year 21 cash basis receipts of $321,615. Fiscal year 22 year-to-date sales tax revenue is $456,044 greater than the May through October FY21 cash basis receipts. Building permit revenue for fiscal year 22 to date is $225,245 or $72,865 greater than the same reporting period last fiscal year. General fund fiscal year 22 total revenues of $7,936,098 are $1,514,960 or 23.6% greater than the October FY21 year-to-date revenues. And fiscal year 22 current expenditures are consistent with or less than budgeted for the total general fund. Fiscal year-to-date expenditures of $5,586,636 are $1,033,726 greater than the expenditures for the same fiscal period in FY21.
Thank you. Thank you, Bettina.
You're welcome.
Any questions to Bettina? Yes.
Yeah, I do. Bettina, there's a chart showing the sales tax revenue, and we can see that the, is in a downward trajectory for 2021. But then there's a corresponding table of sales tax by commercial sector that hasn't been updated yet for the third quarter. So it's through June. And I'm just wondering that, could you first of all, the third quarter ended so long ago, so I'm a little surprised we don't have those numbers yet. But I'm just curious, could you give me some, or us, some indication of what this is representative of? Because it's such a significant drop-off, but there's no corresponding dollar amounts to show us what's going on.
So, I mean, as far as the sales tax revenue by sector, that's calendar year data that's provided by the Illinois Department of Revenue. And I literally take it from their site, and what's available at this time is being presented. They just haven't updated the next quarter yet.
Okay.
And as far as the swings in sales tax, if you go to the line graph, not the bar graph, but there's two charts on the page 3 of the report, it shows the points in the month and when what dollar amounts were received. And you can see that line, when you overlay it with prior years, has a similar pattern. We're just a little higher than in the past. So you can see that the months of September and October and August typically went down. And then as we get back into the winter months, there'll be a slight increase again, just because of the nature of the season. But the pattern is similar when you look at the overlay. It's just we've exceeded the numbers from prior years.
Yeah, it's there. You see a lot of volatility, like 2019, it doesn't do that. 2015, it didn't do it, but then like in 2016, it did. So if you take a historical look back, do you know why that's going? I mean, what that reflects in terms of a reduction, and is it just less spending in October, or? I'm just curious because it's such a drop off, but it's not consistent year over year. It's something.
I mean, I can look at it further and get you some more information.
I'm just curious. It's such an odd graph because it changes from year to year. So I was just wondering if you knew. So when will we get those third quarter numbers?
That's a good question.
I know we are in Illinois, so I get that point. But I'm just curious. So it's a full quarter lag. Is that
right?
That's what you
I
have?
would assume. I mean, without saying for sure, that by the next month report, the numbers should be there.
Okay, good. Thank you.
Yeah.
I actually had the same question than Trustee Bryant, and I saw the curve, and I could not actually get to a pattern that was equivalent to the previous year or the years before.
Right.
And this is probably because we have more revenue in the previous months, and that shows a decline that is more significant in this month. But I believe that we didn't have enough data to actually come to a conclusion at that point.
Right, because I did the same thing. I did a look back, but it was just interesting to me.
Yep, me too.
Thank
Well,
you.
I mean, this year is definitely an anomaly. There's a lot of different things that went on as far as sales tax revenue levels that just weren't typical of any other year. So we had downturns and then upswings, and there's just not a level comparison, really.
Yeah, okay. Thank you.
Sure.
Thank you. Any more questions on this? This is a report, and this is a voice vote. Any more questions? All in favor?
Aye.
Any opposed? The motion carries. Thank you very much. Next is our village administrator's report. Mr. Rivin.
Thank you very much. Just two updates. The first is, and I'm glad the Bjorks are here. The last meeting, you brought up issues about concerns that we shared with regards to how aggressive AT&T was about going out and taking down those redundant poles along East Prospect and going around the corners there. I have connected with the AT&T Community Affairs rep. They are out, and they're going to take down multiple poles along East Washington, Simpson, Scranton, Maple, Prospect, and Ravine Forest Drive this week, is what they're reporting. So, interesting enough, there are other poles that I told them they don't need to work as hard to get down. They still need to get them down, but that were actually multiple years in the waiting, but they're in industrial districts and obviously not a residential district. We're not as worried about it, but nonetheless, they need to attack those on a quicker basis. Got to the head of the line, and I was pleased to report that. So, yeah, now having said that, I would suspect it's not going to happen this week because that's what happens, right? Whether it be weather or a holiday week, but I think the good news is they're on it, is what they're reporting. So, and they had some other locations they want to clarify, but they're attacking it now. The second item I wanted to update the board on, and again, this is going to get a more full report next week, but we spent the entire committee, the whole conversation regarding the Village's Streetscape program. It's hard not to think about it when you go downtown, and it's very active with both people shopping and dining, but also trying to manage the ongoing construction. And actually, it's going to get busier over the next 2 days. They're going to come in and mill and overlay the section of Scranton between Oak and Walnut. So they'll start in the morning milling, and that's grinding off the top layer of pavement, and then start paving. And then the goal is that they'll be done with everything, including striping, as of the end of the day on Wednesday. So parking will be open for diners when the sun goes down, and so that'll be back open and should be active and done for our upcoming It's a Wonderful Life event. So,
Drew,
yes.
on that point, I just wanted to ask a quick question. I know that a lot of asphalt plants have closed already. Are there any concerns, and maybe Jeff could address this, I don't know, but about laying asphalt when it's this cold? Because I just happen to have a family member that works in paving, and it's the paving sets up too quickly. So I'm just worried, this is such an expensive undertaking. We want to make sure this is done in optimal conditions. And when it's this cold, it's really not optimal. That's why these guys are closed. Most of them closed on the 19th. So have you talked to them about, because scarifying and everything is one thing, that's no big deal. That's not temperature dependent, but spreading the asphalt is. And it'll seize up and shrink much faster when it's this cold, and it's unseasonably cold. So I just wanted to put that out there, because I realize this project is underway, but we're in, that could be problematic in the long term. For the life of this. I wish that lovely engineer was here. She could answer all my questions. That was amazing.
Well, Jeff is here. He's not as lovely as she is, but
No
lovely
offense,
nonetheless.
Jeff, but she really was, but that's all she does. And so I'm just curious, because it was a concern to me. I didn't know that. I thought that about concrete, but considering that, I'm worried about how would this impact the lifespan of this asphalt? It's a thought, because we don't really want to be doing this again in 5 years because it was put down when it was too cold.
Jeff, you want to tackle that?
Yes, the guy who's doing the work is Peter Baker, who owns the plant. So there's no worries about him shutting his own plant down when he has work to do. We kind of had thought this was going to have to wait till spring due to the weather, and it got cold a little earlier than usual. Wednesday, I'm looking at the forecast, high of 52. So we have caught a little bit of a break there with this little warm up this week, which should allow us to get the asphalt in spec per IDOT as the proper temperatures. And everything should be warranted and good for the future based on this little uptick in weather. We originally wanted them to do the work today and tomorrow, Monday and Tuesday, but it looks like the weather's actually better Tuesday and Wednesday by warming up to make this a better chance at being a successful new street.
That's good to know. So Jeff, they're going to do everything Wednesday? Because it's just the one block, right?
They may do some of the binder course. They're going to mill 3 inches tomorrow morning. Then it goes back on in 2 lifts. One is 1.5 inch binder and the other is 1.5 inch surface. Some of the binder may be put on tomorrow if they can get it on. And then the rest of the asphalt will be placed on Wednesday.
Good. That's a lucky break, I think, then.
Yeah, so that's why we were originally going to do it Monday. We told the merchants that. We said, time out, the weather's gotten better. We're going to push it back.
Cool.
And so in addition to the milling, they're also going to do any kind of repairs underneath, the pavement they need to do, and they'll do that as well, so.
Good. Thanks.
Any other questions? Otherwise, this concludes my report.
Thank you very much. Next is our village attorney's report. Mr. Friedman, you have a report.
No report tonight.
Thank you. Next would be my report, and I'm pleased to announce that it is this time of the year and the village holiday celebrations. It's a Wonderful Life in Lake Bluff is less than 2 weeks away. So on Saturday, December 4th, from 2 p.m. to 5 p.m., the Lake Bluff merchants, the village, and the Chamber of Commerce will host a holiday pop-up market and festivities in Lake Bluff. Musicians will be playing all afternoon. There will be entertainment and kids activity from 2 to 5 p.m. And the event will culminate at 5 p.m. with the holiday caroling and the lighting of the village green. 24 vendors will be present to offer delightful offering in the holiday market, including, and I will read, and I will be shameless about that, Bonic, that is waffles and food items, the Daily Method for tote bags, accessories, and gift certificates, designed by Charlotte, DMK Metals, European homemade cookies, Golden Working Artists, and those are all business names, by the way. Gourminis, JDR Wines, Lake Bluff Brewing Company, Lake Bluff History Museum, Lake Bluff Public Library, Lighters, local honey, perfect. Lincoln Land Kettle Corn, McMahon Gallery, My Charcuterie, I can say that in French, Pam Plotzer, Pens by Jean, Petals by Pine by Design, Ronnie's Whore, that is custom maps, puzzle, frame decor, and life maps. The Scout Store for LFHS, Toffee Traditions, Umland Crunchy Cheese Bites, Vintage Magnality. And also a big thanks to thank you to the wonderful entertainers joining us. That would be the Buckthorns, the Lake Forest Civic Orchestra Brass Ensemble, and the Lake Forest High School Holiday Brass. And all information can be found on the Lake Forest Lake Bluff Chamber of Commerce homepage. Okay, and that concludes my report for today. Any questions? I'll see you there on Saturday. Next, item 10 is acceptance of a correspondence. Please note that all correspondence was delivered to the Village Board of Trustees in the informational reports on November 5 and November 12, 2021. Is there a motion to accept the correspondence?
So moved.
Thank you. A second?
Second.
Any discussion? Hearing none, clerk, please call the roll.
Trustee Inkman?
Aye.
Trustee Brienne?
Aye.
Trustee Fisher?
Aye.
Trustee Markey?
Aye.
Trustee Rappin?
Aye.
Trustee Ryder?
Aye.
Thank you. Next is item 12, a public hearing regarding year 2021 property tax levy. The Village of Lake Bluff, in keeping with past practice, will conduct a public hearing on the proposed YR 2021 property tax levy. As part of a hearing, Finance Director O'Connell will present information on the Finance Committee's tax levy recommendation. The hearing notice was published in the Lake County News Sun on November 9, 2021, and on the village website on November 17, 2021. I would say please refer to the subsequent 2 agenda items for the proposed tax levy information and ordinances. And as such, I declare a public hearing open regarding our year 2021 property tax levy. Finance Director O'Connell, could you please provide us more information?
Sure. Let me just share the screen. Oh, Glenn, can you give me screen sharing ability?
You got it.
Thank you. Can everyone see that okay?
Yes.
Good evening, and thank you for allowing me the time to present some information on the 2021 property tax levy. This levy presentation is for the property tax bills that will be sent to property owners in May of 2022. From 1818 to 1930, amendments to the Constitution provided the state with various powers and authorities concerning property tax. The Revenue Act of 1872 gave Illinois final authority for setting valuations, and the last year the state levied real estate taxes was 1930. Since then, property taxes have been levied at the local level. Some topics to be covered this evening are the sources of revenue, the assessment cycle, how tax dollars are used, some historical or data information, and the impact on a median family home. The village has several financial policies which guide the preparation of tax levy and the budget and allow the village to proactively seek solutions to change revenue streams. Some of the more significant practices are to balance revenue sources between taxes, user fees, and other sources to reduce the reliance on any one source, to be prudent in the expenditure of funds, to maintain adequate operational reserves, to fund the pension requirements as determined by the actuaries, and to not use non-revenue sources to finance operational expenditures. And this chart just gives a breakdown of the sources of revenue. So part of the important process in the tax levy is the tax assessment cycle. And the timing of the determination of the tax levy amount creates a challenge because it occurs prior to the preparation of the fiscal year annual budget and the period during which funds will be used. The property tax rate is determined by the Lake County clerk and appears on the property owner's tax bill. The tax rate is applied to a property's assessed valuation, which determines the amount of money the taxpayer pays to the village and other taxing districts. The village is only one of many taxing bodies which appear on the annual property tax bill. From a levy perspective, the process as a home rule community, the village is not subject to Property Tax Limitation Act or PTEL. However, a resolution was passed in 2005 committing that the village abide by the PTEL limit. And this means that any increase greater than 5% or CPI, whichever is less, would require a public hearing for approval. So an estimate of taxes to be levied in the form of a levy ordinance must be prepared not less than 20 days prior to the adoption of the levy. As far as the assessment process, first the township assessor calculates the assessed value of property. Annually, the Lake County Chief Assessor determines the level of assessment in each township based on 3 prior years of sales transactions. The equalization of assessed values is important. It's the application of a uniform percentage increase or decrease to assessed values of various areas of classes of property in order to bring assessment levels on average to the same percent of market value. The county chief assessor adds a multiplier to all non-farm parcels based on analysis of change in assessments for each class: residential, commercial, and industrial. The levy cycle on the municipal side includes budget prep, budget notice and hearing, budget ordinance approval, publish of the tax levy request, and the tax levy certification to the county in December. So how are the tax dollars used? The village portion of the tax bill is 9%, which will, while the remaining taxing bodies range from as high as 40% to as low as 0%. This chart shows the assessed value by class for the past 10 years, along with the tax extension over the same period, while comparing the correlation to EAV. And the chart includes the library extension. So the slope of the orange line at the top shows the total EAV peaked prior to 2011 and then declined by 25%. The 2021 estimated EAV has also declined from 2020. So what changes the EAV? Market value and income generating capacity of current properties and new construction or annexation. And the village has had no annexations of property since 1998, when the sanctuary subdivision became part of the municipal boundaries. So if it's fun, there are some fun facts. The total levy is $4,556,707, which is slightly different than what was originally calculated, because the EAV decreased a little bit from the original estimates from the county. But compared to prior year, the extension was $4,476,317, based on the consumer price index factor of 1.4% and estimated new construction of 2.2 million. The total EAV estimated to decrease by 1.62%. The levy itself increased 1.796% from 2020. The anticipated Lake Bluff Library requested property tax levy is $1,032,728 for the year. Last year's request was $1,014,510. Levies are made in dollar amounts, and to raise the money requested in levies, the county clerk must calculate a tax rate for each fund for which the taxing district levied. The tax rate's a number that, when multiplied by the tax base, will produce the levy amount. And these are the estimated based on the current EAV resulting rates for each part of our tax levy. Take us to the total 4.5 million. The breakdown by function, this chart shows the levy by purpose. However, it's important to note that the levy does not fully fund these functions. The village relies on multiple sources of revenue, such as sales and other taxes, building permits, and other user fees, and licenses and fines to cover the costs of providing services. So what's the impact on an average homeowner? As you review the impact of this levy on a home worth $642,700, it's important to note that the effective rate, which is based on the total actual EAV. The current EAV numbers are projections, and they're provided by the Lake County Assessor. So the change from prior year to this year would equate to approximately $50.35. So compared to other communities, the village's tax rate remains lower than most, and subsequently the tax amount for a median market home is lower in comparison to most comparable neighboring communities. So what this means is the median market value home is $642,700, calculated based on the total rate for all the neighboring communities, and what that property tax would be in those towns, assuming there was a home of that value. And that's the hearing. Does anyone have any questions?
Thank you very much. I will now welcome member of the public comments. Do we have comments online?
None online.
Any more comments by this board?
I did have a question. At the last meeting, when we talked about this, Bettina, there was something that you didn't include here, which was that due to the EAV decrease, that there would be a shortfall, and it numerically came out to about $77,000. And forgive me if this is an ignorant question, but in order to cover that, is it possible, I mean, we move money around all the time to, and as you know, with my vote from last time, I'm not inclined to want to do this because I think the future is going to be worse. But I'm just wondering if we can make up the shortfall in a way other than increasing the levy. I mean, there's a difference there. I believe it was about $77,000. Am I wrong or right?
No, you're, so the $77,000 was had there been a freeze. The difference is $15,665, so that's the net change to the general fund.
Okay.
And the police pension levy increased that portion of the levy by $77,835. So that total brings us a net increase of $62,170.
Right. So our option was to use CPI, not use CPI, or freeze.
Right.
So
correct.
when we look at that on the packet here, our options are also to not raise the levy, but if we didn't do that, there's this negative number, and I'm just wondering if we don't do it, is there a way, because it was mentioned that we're in a healthy place with reserves, and so I feel sort of like when Barbara says, you know, I'm not a lawyer, I'm not an accountant, but I'm just asking the question, is it possible to make up that difference so that we are in the same financial place by using money we already have as opposed to reaching into the pockets of residents?
I mean, are you asking if we can spend fund balance dollars to make up the difference if we froze the levy again?
Yeah.
Sure, that is a possibility, as it could be in any given year, assuming the fund balance is healthy.
Okay.
However, you have to remember that this is an accumulative process, and each year that the levy is frozen or CPI isn't taken, the following years are affected by not taking those increases. And
Right.
if next year's increase is higher, that could have a bigger net effect.
Right, and that was the point that Trustee Ryder made at the last meeting, was she'd rather do it incrementally. My prediction is that the CPI we'll be working with next year will be over 5%, so we'll be in a position potentially to take the PTEL max, especially if we see a sales tax reduction that I anticipate. So that's what I was wondering is what were our choices? Because I'm never inclined to raise taxes if there's even a little bit, or even in comparison to other communities, because they have I'm sure there are other factors involved. But I just wanted to know what the ramifications would be, and you just alluded to it. So if we were to freeze, since it is a cumulative effect, what position that would put us in next year? For example, you froze last time, right, last year in 2020?
Right.
Okay,
So we did, and then you lose the opportunity to recapture the dollars that weren't taken in the prior year.
right.
So each year incrementally, there's an increase that you're not taking, and it affects the following year's increase because you can only apply the multiplier to the prior year's extension. So when you don't take the full amount or part of the full amount, you lose the ability to calculate the percentage higher on that number, if that makes sense.
That does make sense. And it plays into my other point, which was that would reinforce my request that we set aside any plans to spend anything that isn't categorically necessary. Because if we were to freeze things. But I get your point, and it makes sense. I do. Thank you.
Thank you, Kate.
You're welcome.
Thank you. Any more points? Any more questions? Hearing none.
First reading, voice vote's fine.
So it's a voice vote. Anyone in favor?
Aye.
Anyone opposed? The motion carries. Thank you very much. And if there are no more comments, I will now declare this public hearing closed.
I just want to reiterate that I only voted by raising my hand.
Which hearing?
I was a no vote. I realize I have to speak. Sorry. Yeah, that was a no.
Well, procedurally, to be clear, that was a public hearing.
Right.
So the idea that the village president declared the public hearing open, I think the best conclusion is if there's without objection, he can close the public hearing and then consider the ordinance,
The levy ordinance.
the levy
Item
ordinance, and then
15.
the abatement ordinance.
Correct.
Okay,
So you can go to the next page.
okay.
So you should declare the public hearing closed.
I did. I now declare this public hearing closed. I will say that.
Oh, you did? Okay, sorry.
Yes. The next is item 13, an ordinance levying property taxes for the fiscal year beginning May 1st, 2021 and ending April 30, 2022 for the village of Lake Bluff, Lake County, Illinois. Is there a motion to approve a resolution?
So moved.
The ordinance.
So moved.
Thank you. A second?
Second.
Thank you. Pursuant to state law, on or before the last Tuesday in December, the village must file with the county clerk an ordinance requesting a property tax to be levied on all taxable property within the village. After review of levy estimates and financial projections as presented by staff, the Finance Committee at their October 25th meeting unanimously recommended approval of an aggregate property tax levy of $4,556,637. Subsequent to the Finance Committee meeting, the county assessor provided updated AAV estimates that were used to make an adjustment to the aggregate tax levy of $4,556,707. The village share of a property tax levy is $3,523,979. It is anticipated that the Lake Bluff Public Library Board will request a property tax levy of $1,032,728 for the year 2021. The total levy amount of $4,556,707 is in compliance with the Property Tax Limitation Act, and the Truth in Taxation Act was not required for this levy. Any questions, any discussion? Hearing none.
First reading, voice vote.
It's a first reading voice vote. Anyone in favor?
Aye.
Anyone opposed?
Nay.
This is an ordinance.
Yeah, it's first reading, so it passes on.
Passes.
This is passes on first reading. Thank you. Item 14, an ordinance abating year 2021 property taxes levied for general obligation debt series 2019 and 2019A bonds for the village of Lake Bluff, Lake County, Illinois. Is there a motion to approve a resolution to the ordinance?
So moved.
A second?
Second.
Thank you. The village currently has refunding bonds, Series 2019 and 2019A, general obligation, GO bonds outstanding. Pursuant to ordinances 2019-18 and 2019-26, the county clerk is required to extend a property tax levy in an amount sufficient to pay the interest and principal on the bonds. Fortunately, the Waterworks Fund has adequate funds to transfer to the Waterworks bond and interest account for principal and interest payments on the 2019 general obligation bonds and the 2019A refunding bonds, which allows the village to abate the annual property tax levy. Because the bond ordinances directing extension of the annual property tax levy were filed with the county clerk, an ordinance is required to abate, not levy, the property tax for these bonds. Questions? This is a hearing, no questions. This is a voice vote. No, this is a roll call vote.
First reading, it's voice
Voice
vote.
vote.
I know it says that.
It's wrong.
It's wrong.
That's my typo. I apologize.
So it's a voice vote, and it's for a first reading. All in favor?
Aye.
Any opposed? The motion carries. Thank you very much. So next is item number 15, an ordinance approving a final plan and special use permit for Lot 1 of Arden Shore Subdivision 425 to 429 Shore Acre Drive. Is there a motion to approve a resolution?
The ordinance.
To approve the ordinance, sorry.
So moved.
Thank you. A second?
Second.
Thank you. In March 2021, the Village Board approved Ordinance 2021-5, which authorized a subdivision and a number of variations for the Arden Shore subdivision. The subdivision concerned the site of a former Arden Shore Child and Family Services campus, a group home and residential program that ceased operations in 1995 and has remained vacant since. The subdivision and variation contemplates the subdivision and variations contemplate the development of the western 18.2 acres of a site as a practice ranch for Shore Acre Golf Course and the eastern 7.8 acres as a single-family residence complemented by 2 accessory dwelling units. In the absence of final plan that would typically be required before awarding a variation, Ordinance 2021-5 approved the variations contingent upon the PCZBA and the Village Board approving a final plan that met certain conditions. In October 2021, the village received a proposed final plan for approval. The final plan proposes the construction of 2 accessory dwelling units as well as a residential pool house with light, heat, and bathing or shower facilities. The applicant has represented that these facilities were originally intended to reside within an accessory dwelling unit and were separated for architectural reasons. This pool house is nevertheless governed as a special use under the village zoning regulations and require the approval of a special use permit to construct and use. The attached PCZBA memorandum provides additional detail. The PCZBA opened a public hearing concerning this application at its November 17 meeting. At the conclusion of the hearing, the PCZBA recommended unanimously that the village board approve the final plan and grant the special use permit in the form of the attached draft ordinance. Any questions? Hearing none.
This was approved by the PCZBA, right?
Recommended for
Unanimously,
approval.
recommended?
Yeah.
Okay.
Last paragraph. Yes.
Yep.
I actually had a question about the densities. I'm going through this, and forgive me, I'm looking at the, what's the total square footage relative, is this almost an 8-acre lot?
Right.
Okay. Interesting. So they're really not that big. I just think it's interesting because they've been considering these ADUs and we haven't really talked about them. So it's kind of interesting that this comes up when we have not had a chance as a group. I know the PCZBA is considering it, but
Yeah, this is.
how, if
yeah.
at all, is this going to have, since seems not to be in conjunction with any sort of policy discussion about them in the village. And I realize this is a substantial piece of property, so it's not like putting it on the east side of town, but still, once this happens, people will be more inclined to be maybe aware of it. So what gives in that regard?
Well, I think you highlighted a number of reasons why the PCCBA recommended that this be processed in this manner. There has been another subdivision in this very vicinity just to the southeast where they've considered an additional dwelling unit on a property before and granted a variation regarding the same, or recommended going that pathway. So this pathway is not the first time it's been, gone down that road particularly. The scale of the property you talked about was one of the considerations, and also just how modest the improvements were. There were certain limits going into this, but they were well beneath that, very low-key, low-scale structures. I think this, as well as another property, there's been another project floated for Block 3 on the eastern side of that property that the owner has workshopped
Right.
an ADU, kind of a granny flat, if you will.
Right.
We're certainly, that scale as well as this were in their minds when they've been talking about accessory dwelling units. If you recall, at the last meeting, I reported out that that's coming back. There was a hearing held, and you'll see that at the next board meeting, the recommendations about how to manage ADUs as a special use moving forward. And so they certainly were aware of this, and I think that served as a good backdrop to aid in their conversation, really just help facilitate it and, how they wanted to manage it
Right.
moving forward, so.
Because this is ideal, but on a much smaller lot, it's much more complicated. It's one, if you have an 8-acre parcel, obviously putting a 2,100 square foot building is,
Almost unnoticeable.
it's really not a big
Right.
deal. The location of this, it's unobtrusive. This is extremely private. So this would be ideal. So I guess what I'm asking is, or we'll be interested to see how we deal with it when it's not any of the above.
So, and that's why the special use permit process makes it, you take them one-on-one, look at them versus being as of right. And that was something that the PCZBA struggled with for a long time, is trying to find what was the right formula, what was the right approach, the right conditions, limitations. And it's very difficult when you're comparing and contrasting zoning lots of such a variety, right?
Indeed.
And so that's how they ended up where they ended up.
Any more questions on the board? It's a first reading and it's a voice vote. All in favor?
Aye.
Any opposed? This is an ordinance, this first reading carries.
Yeah. So you'll see all these again in December, plus. So,
Okay.
Good.
yeah.
Next is our trustee report. Do any trustees wish to make a report this evening? Thank you. Next item is item 17, consideration of a November 8, 2021 executive session meeting minutes. Is there a motion to approve a resolution?
So moved.
Thank you. A second?
Second.
Any questions? Hearing none, clerk, please call the roll.
Trustee Rappin.
Aye.
Trustee Ryder.
Aye.
Trustee Inkman.
Aye.
Trustee Brienne.
Aye.
Trustee Fisher.
Aye.
Trustee Markey. Aye.
Just that.
Thank you. Thank you very much. Next, I understand that we have an executive session tonight. Might I get a motion to go into closed session to discuss pending personnel?
Personnel.
Personnel, thank you very much.
So moved. Second.
Thank you very much. Clerk, please call the roll.
Trustee Ryder.
Aye.
Trustee Inkman.
Aye.
Trustee Brienne.
Aye.
Trustee Fisher.
Aye.
Trustee Markey.
Aye.
Trustee Rappin.
Aye.
Thank you very much. So this concludes the open part of a village board meeting. Thank you to anyone, Mr. and Mrs. Bjorn, for in attendance this meeting, and have a great evening.